I'm very happy to have all of you here today, and I will try my best to answer questions that you may have. I'm not an immigration attorney, and even if I were an immigration attorney, I'm going to have to tell you that we can only answer more general questions. Deep in personal questions regarding your personal situation, we would have to have you schedule an individual appointment with somebody. But in general, we'll break down the immigration system for you from OPT to beyond OPT. So, and Tomer, my wonderful colleague from the international student side, is helping me with that. So thank you, Tomer. All right, what we're going to cover today is the immigration framework from basically OPT to permanent residency, not suggesting that OPT will eventually always have to or will result in permanent residency, but oftentimes we do get asked about permanent residency. The main employment-based visa is the H-1B visa, so I'll cover some basic information with you. And then also, we all know about the H-1B cap situation. I'll explain that also a little bit in the next few minutes, and some alternative options if the H-1B does not pan out as expected. And then, of course, I'm leaving time for questions. I have to apologize in advance. My cat is very, very snuggly today. He also has an opinion on everything that he is not concerned with usually. So he might make an appearance on the screen, and I apologize. But I'm just trying to keep him just hidden on my desk as best as I can, but don't freak out if there's a fluffy black thing. It's not a ghost, it's just my cat. All right, so congratulations, you've all completed your degree, or if you're not completed yet, you will complete shortly. You're amazing. You made it through education, very rigorous education at UC Santa Cruz, and then of course, being an F1 student, you're eligible to apply for OPT, and if you're in one of the STEM designated fields, you can apply for STEM OPT. But once you come to the end of your OPT or STEM OPT, what happens then? What are your options then? And again, this is not a workshop on how to become a permanent resident in the US, because as many people as there are in the US, there are many, many different options and many, many different paths. And depending on your individual circumstance or what happens in the future, there may be options and opportunities for you in the future that you haven't thought about and can't conceive of right now. So options beyond OPT, I have to tell you, when you're looking at your immediate future, sometimes, going home might be a good option. Growing opportunities in many, many different countries. And of course, family ties. We all got older, your parents get older. And sometimes what you don't think about right now is that, you might want to be closer to your parents when they age. I'm originally from Germany. I immigrated into the United States, and that was not one of the things that I was ever concerned about. I was concerned with my future. I was concerned about finding a good job and staying in the US. But then I never thought about my mom getting older and getting sicker. And so sometimes I wish I had thought about that. Going to a third country, you are already experienced in cross-cultural adjustment. You've all successfully transitioned to the US. Some of you have even lived in a country before you came to the US. You will have great work experience in the US, and you have marketable and transferable skills that will make going to a third country an actual option for you. And then, of course, do you want to stay in the US? Do you have an opportunity to stay in the US? on an employment-based visa once your OPT or STEM OPT expires. And then looking at what your long-term plans are. Do you think this is a country that you would like to spend most or the rest of your life in? Do you feel comfortable here? Do you want to stay here more permanently? So any of these questions, we're not going to answer today. Those are questions that you can ask for yourselves and of yourself and discuss with your family members if you'd like. But all of these are reasonable, rational questions that go into what your options might be beyond OPT, and even any of these options is a valid option. So oftentimes when we talk about options beyond OPT and employment in the US, the permanent residence comes up. Now, permanent residency is not necessarily a automatic experience for people in the immigration journey. It's not an automatic F1 OPT, STEM OPT, H1B permanent residency. Seamless experience. Employment-based immigration is one of the paths to permanent residency, but so is family-based permanent residency. For example, if you fall in love with a US citizen or a legal permanent resident and you get married to them, unless you're already married, then you first have to get a divorce, unfortunately. But if you fall in love with a US citizen or a green card holder, they can sponsor you for permanent residency. Or if you have a brother or sister who is a US citizen or permanent resident. So family-based immigration is still a big cornerstone of permanent residence. Then, of course, there are humanitarian concerns that I don't wish on anybody, like asylum, refugee, displacement status. Some domestic violence cases can also put you on the road to permanent residency. Again, those are not things that anybody should aspire to. I have seen in my long work with international students, I have seen home countries fall apart and students needing to resort to one of the humanitarian reasons for permanent residency. And that was very, very sad for the students and for their families. And then, of course, there is the diversity visa lottery, where anybody from a not that populous, not that populated immigration country can apply to. So anybody from Europe or some countries in South America can apply to the diversity visa lottery. Unfortunately, people who are coming from countries where we have a lot of immigration from, such as India and China, you have some of the most people. You can send some of the most people abroad. And there's a lot of willingness to move to the US. So unfortunately, you would not be eligible for the diversity visa lottery because the US already feels like we have a lot of people from populous countries here. So you would have to figure out a way to either marry a US citizen or get a great job and then immigrate if you wanted permanent residency. Again, any of these paths to permanent residency can be a very long road, and it's not an automatic path for anyone graduating from a US school that you automatically get put on the path to permanent residency. Unlike other countries with a more comprehensive international education policy that really have a drive to maintain and retain high talent and outstanding educated people, the US has not gotten to that point yet, unfortunately. And I should say not the US, but some people in the government haven't gotten there yet. So employment-based permanent residency, again, it's kind of like the elephant in the room. Most of the cases follow these steps. There's a prevailing wage determination with the Department of Labor, which can take between 6 to 9 months. Then there's a labor certification with the Department of Labor that can also take between 9 to 12 months. Then there's the immigrant petition for alien worker. That is filed with the US Citizenship and Immigration Service. There's premium processing available for that. So that could be very, very quick. And then the very, very last step in all of this is the application to register or adjust status to permanent residence, the so-called green card application. And if everything goes well and the green card is available, there is currently a 12 to 15 months, if not longer, processing time. Unfortunately, right now, there is no premium processing for that part of your immigration journey. And if you're from a country such as India or China, you have a priority date, which may not necessarily be current. So a green card may not be available to you. Those priority dates depend on the category that your permanent residency is filed under and your country of citizenship. And so it could go from immediate to 7+ years. Sometimes with family-based immigration, it's up to 20 years. So despite doing everything the right way, despite following all the steps, it is an arduous process. It's not guaranteed, and it's not always the fairest process either. But now we've looked at the long-term future potentially. We've gotten the permanent residency out of the way. And now we have to figure out what's in the more immediate term or medium range term for you. So if you want to stay in the US beyond your OPT and you want to be working, there are some employment-based visa options. So specialty occupations, there's the H-1B. We have the O-1 for people with extraordinary ability or achievement. So if you were an actor or actress, winning an Oscar would be great. Winning an Emmy, a Grammy, an Oscar, and a Tony Award, so getting EGOT status would be even greater. And so it's basically people with very, very high caliber. Winning the Nobel Prize for chemistry would help, or finding the cure for the common cold would probably also help. Then there are regional trade agreements, TN, NAFTA, no longer called NAFTA, but the visa is still called TN, and the E3, which is a specialty occupation for Australian citizens visa. And then there are intracompany transferees as well, the L1 or L2 status. Now, employment-based visas, again, do not automatically lead to a green card. They can be a path toward permanent residency, one of several paths. But what they do is allow you to be working in the US, and they allow your US employer to fill a job opening by hiring a very well qualified individual who happens not to be a citizen or legal permanent resident. The H-1B is basically kind of like the default employment-based visa, kind of like the F1 student visa is the default student visa. The H-1B is defined as a temporary non-immigrant visa category for foreign nationals that are coming here or that are currently in the US and are going to perform services in a specialty occupation. The H-1B is employer specific. It's possible that you can work for more than one employer, but both of your or all of your employers must file an H-1B petition for you. The employment that you undertake must take place within the geographic region that is stipulated in the petition. So if your employer says, oh, you're going to work in Silicon Valley, and then they're going to have you work in Texas, they have to submit an amendment to your H-1B petition. H-1B status is limited to 6 years maximum. There are some, exceptions to that that I can get to in a moment, but it can be extended once you're in the final stage of the green card process. And it definitely basically is a two-part process involving both the Department of Labor and the US Citizenship and Immigration Service, so two agencies of the US government. The advantages of the H-1B The biggest advantage is that it allows for dual intent. Now, in the past, when you've applied for an F1 visa or for a tourist visa, even before the F1 visa, if you came here as a tourist, you had to establish that you have significant ties to your home country. And so we've always basically recommended that you apply for your F1 visa in your home country. The dual intent of the H-1B visa means that the ties to the home country, whether you have ties to your home country and you want to go back home or you don't want to go back home, do not figure in the determination by the consular officer to give you the visa. So that's a huge, huge advantage, because you can, if you are going for a green card, you can travel and apply for an H-1B visa while you're in the green card process. Whereas applying for any other temporary non-immigrant visa category with the green card, being in the green card process would be considered not appropriate. There is a cap, but for example, you're not subject to the cap if you're taking a short break in your H-1B status. For example, you work at a company for 2 years or for 1 year, and then you find out that you have much better chances of getting promoted and even better salary if you get an MBA or another master's, or a master's if you now have a PhD, and you go back to school for 2 years. If you are a break in if you haven't exhausted the 6 years of H-1B status and you take a break, and you were subject to the cap within the last 6 years, you can resume your H-1B without being subject to the cap. You can recoup time that you've spent outside the US. So please, I know that travel is now electronically registered. You can get electronic I-94s, and you can get your travel and reentry record electronically. So please make sure, though, that you still keep, printed out travel schedules or boarding passes, because sometimes it doesn't, the system isn't always correct. Anytime you spend outside the US, if it's more than 24 hours, you can add on to your H-1B at the very end. If you go outside the US for 1 year, your H-1B clock resets, so you can get another 6 years of H-1B. And you can change your employer. The new employer files a petition, and once you receive the receipt notice from the immigration service that they've received the application from your new employer, you can already start working at the new employer. So you're not locked into that one H-1B employer or the 2 H-1B employers. You can change employers. The limitations of the H-1B visa are that there is a cap and there's a lottery system. It's still considered a non-immigrant visa status, still considered temporary. There is no guarantee to get a green card. You can't accept additional employment unless another petition is filed on your behalf by the second employer. You're not eligible for an H-1B visa if you've ever had J-1 status or J status, period, and you were subject to the 2-year home residency requirement or 212E. Changing to an F1 after that does not take away the responsibility to go back home. And if you're subject to the 2-year home residency requirement, you can't get an H-1B visa from the embassy or consulate abroad. It's limited to 6 years total, so it's not, indefinite. And you do get a limited grace period, and that is not automatic. If you're laid off, we've all heard unfortunate news from the tech sector close to us in Silicon Valley. If you do get laid off and you find another employer within 60 days, that new employer can request the 60-day grace period that would cover you. And be retroactively awarded to you when they file the new petition, but it's not an automatic 60-day grace period like you would have at the end of your OPT or the end of your F1 status. Now, what's a specialty occupation? Specialty occupation requires at least a bachelor degree in a specific academic field, and the job has to require that. So, for example, assistant professor would require that you have at least a PhD in computer science if you were going to be a computer science professor. If you have a foreign degree or a degree from a non-US institution, that needs to be evaluated by a formal evaluation service. And if your diploma doesn't have a major listed, sometimes even if you have a diploma from a US educational institution, it doesn't list your major, then you need to also provide your transcript with that. The candidate or you must meet the minimum position requirements at the time of filing. So if it says a master's in computer science is required, and the employer files for you on April 1st, but you don't get your master's until April 30th or May 15th or something, you haven't met the requirements. And then if you do have any license or there's any certification required for your employment, for example, if you work as a pharmacist or if you work as a counselor, as a psychotherapist, you need to have that certification or license at the time your H-1B is filed. So that's the specialty occupation piece. Now, employer responsibilities. The employer has to be able and willing to pay the required wage, the filing fees, and the attorney fees, unless they have their own in-house attorney. The required wage is the higher of the actual or prevailing wage, and I'll get to that in a second. The employer has to be providing you, the beneficiary, with employment that is according to the stipulations in the position. So the job duties that they posted and the job duties that they submit the petition for have to be the same job duties that you will be working on. The salary has to be the same and the work location has to be the same. So they can't just switch things around on you legally. The job must make sense for the business, and they must notify other workers of the terms of the job, including your salary. So they must post this job or provide a notice of, posting the labor conditions and the job terms in a publicly accessible space. Now, if you have the unfortunate experience to be terminated employment, your employer has responsibilities that they have to meet. The employer is required by law, by Department of Labor rules, to offer return transportation to the last physical residence that you had outside the US before you entered H-1B status. If they're terminating your employment prior to the end of your H-1B status. And the employer must notify the Department of Homeland Security, in this case, USCIS, as well as the Department of Labor, that they have terminated your employment. If they don't do either or both, and sometimes people forget, they may be liable for paying you back wages. So if they lay you off, and they don't notify anybody and they don't do anything, you're still technically on the record for Department of Labor and USCIS, and you could be entitled to back wages. So you do not have to accept the offer of return transportation. And what that means is basically, in most cases, it's an economy class ticket for yourself to your home country. You are not required to accept that offer. They have to extend the offer to you. They are not required to give you the equivalent in cash, though. So you can certainly say decline the offer, but you're not entitled to say, oh, I'd like for you to give me the cash money, the cash value. About wages. So I mentioned prevailing wage, actual wage, and the required wage. The prevailing wage is something published by the Department of Labor. It's the wage paid to similarly situated employees in a specific occupation in the area of intended employment. In the case of union positions, the prevailing wage is basically determined by the collective bargaining agreement. The actual wage is the wage paid by the employer to other workers in your similar position with similar experience and qualifications to you. And so the required wage is basically the higher of the two wages above. So basically what that means, and what you may have heard David Ware say in his presentation, is that it has to be a competitive wage. And typically industry pays very competitive wages. So in most cases, you don't have to worry about this piece of the H-1B process. The H-1B process, again, is a two-step process: labor condition application with the Department of Labor. There is no fee. Takes 7 business days to be certified. And what that does is basically it establishes, does the job meet the requirements, that the employer acknowledges responsibilities, and that everything is according to US labor laws, and they're not using your H-1B to undermine US labor. Once that is done, then the USCIS process takes place, and that's the petition for non-immigrant worker. With the premium processing in place, it takes about 15 working days, 15 business days. Otherwise, it could take 7 to 9 months without premium processing. And then that is basically a determination whether you meet the requirements of the H-1B classification, whether you are qualified for that. Looks at your education level, at your degree. And if you're currently in the US, it looks at whether you have maintained your legal status and are now currently lawfully present. The fees, there for private industry, there are quite a number of fees, and they must all be paid by the employer with certain stipulations. The filing fee is $460, fraud detection and prevention fee is $500, and then there's an education and training fee depending on the size of the employer or the company. It could be $750 or $1,500. All of these fees are required to be paid by the employer. Premium processing fee is $2,500. And then if you have a spouse that's currently in F2 status, then there would be a change of status application for your spouse and your children, if you have children in F2 status, and that would be $370. Now, the dependent change of status fee can be paid by you. Your employer can ask you to be paying that fee. And if you say, well, you know, my H-1B, you know, I need to travel, and this kind of like, I'd rather have my H-1B go through premium processing, even though I still have like 2 years left on my OPT or something. I want you to do the premium processing fee. If it's personal, your personal reasons, not a business reason by the employer, but your personal reasons, then the employer can ask you to pay that premium processing fee. It's not necessarily always the case that your employer will say pay that, but the regulations say it has to be paid by the employer if it's a business decision. If it's a personal decision on yourself, then you could be asked to pay that money. And then, of course, unless the company has in-house legal attorneys, they will have to do an outside attorney, and so that could be $2,000 to $10,000 per petition, and that is also payable by the employee. By the employer, not you. You're not paying for the attorney. Statistics, you know about the 65,000 limit for H-1Bs, plus then the 20,000. So the first 20,000 H-1B petitions for anyone who has an advanced degree, master's or PhD from a US higher education institution is excluded from the cap. Once 20,001 petitions have been filed, then those get into the pot of the cap. There's additional visas for Singapore and Chile that are not included in the cap, and then extensions and transfers are not included in the annual cap either. But you can see, from the statistics, fiscal year 2022, so for an H-1B starting October 1st, 21, the USCIS received more than 300,000 applications. They selected 132,000 and 3 drawings. Not all of these qualified. And so, they ended up with those 65,000 later. And then 2023, the most recent year for which we have statistics, it's 484,000, close to that, applications, registrations received, and they selected once and picked out 127,600. So it is a very unfair system, unfortunately, because it's a numbers game, it's a lottery. The more people apply, the lesser your chances are. And there's not much that you or your employer can do to influence this at all. They need to do the registration, which starts today's the 27th. It starts the day after tomorrow. So March 1st through March 17th is the registration period for cap subject H-1Bs, but that's basically it. Don't have your employer submit more than one registration for you. That's considered fraudulent. Don't have multiple employers, multiple prospective employers submit registrations for you, because that is considered fraudulent. Because how could you be agreeing to be working for 10, 15 different employers? That's just not possible. So yeah. Now, you've done everything correctly, your employer has done everything correctly, and the lottery just hasn't worked out, unfortunately. There are some alternatives. There's the O1 that we often get asked about, the E3, the TN, and then the Intracompany Transferee, L1 and L2. Those are the main alternatives. All of these employment-based visas assume temporary non-immigrant intent. So unlike the H-1B, all of these assume that you have intent to return to your home country and that you're only going to be here temporarily. So that's the downside for that. The O1 visa is, again, for people with extraordinary ability. There are 8 criteria, and you have to meet at least 3 of those 8 criteria. And the advantage of the O1, there's no cap. No cap, even if you're working in private industry, there's no cap to an O1 visa. You're eligible to get an O1 visa, a visa stamp, even if you are subject to the 2-year home residency requirement. And your O1 can be renewed multiple times. You can get an O1 for the initial 3-year period, and then you can renew it, on a yearly basis. The limitation of the O1 is that it still has the non-immigrant intent. It's very, very hard to get, and the decision is discretionary. USCIS basically determines if they believe the criteria are met. And so they have a guidance manual and they have policies that they are supposed to follow, and they do follow. But somebody determining whether you are as outstanding as your case might suggest is still very subjective. Whereas somebody saying, you're going to get this much salary for this job is less subjective. It's basically just adjudication. And lastly, having an O1 visa does not guarantee successful application for a green card. There's an O, outstanding researcher, professor, outstanding employee, kind of worker green card path, but that's not guaranteed just by having an O1 visa. Then we have regional trade agreements. The TN, trade NAFTA, NAFTA, it's for citizens of Canada and citizens of Mexico. So if you're not a citizen of either, that doesn't apply to you. And it's a narrow list of professions. The benefits are that citizens of Canada do not need a visa. There's no special process for citizens of Canada, unlike citizens of Mexico, unfortunately. And then we have the agreement with Australia where you have to be a citizen of Australia, and then you could qualify as a specialty occupation for an E3 visa. Again, all of these options assume temporary employment only, no dual intent. It doesn't mean that you're prevented from applying for permanent residency or that your employer is prevented from applying for permanent residency on your behalf if you hold any of these visa options. But it gets a little bit more tricky if you want to travel and you need a new visa, or it makes things a little bit more tricky. Then there is lastly, the intracompany transferee. And that basically is if you've worked in a multinational company for at least a year abroad. Let's say you choose to go home now that your OPT, STEM OPT might be over with. You choose to go home and you end up working for like 3M or Honeywell or Microsoft in your home country, or Apple in your home country, and for at least 1 year. And then they want you back in the US, either because you're a manager, hold executive position, or because you have very specialized knowledge. You could qualify for this. But the issue with that, the limitation of the L1, L2 is that you can't transfer that visa to another company, whereas you could transfer the H1B to another company. You could get an O for another company or another employee and transfer that. You can't easily or at all transfer your L1, L2 visa to another company. So I've put together some resources for you because I've looked at the David Ware webinar, and some of the links that he mentioned there were no longer functioning. So the database of H1B jobs, finding an employer that sponsors for H1Bs, that's the first link there. Then if you're interested in salary information, there is the FLC data center. That's the statistics from the Department of Labor that my colleague Elena and I use when we file H1B petitions for the university. There is Working in the US from the US Citizenship and Immigration Service. It's a fairly good, interesting also read about the different employment-based visa options in the US and what it takes to get one of them. And then if you are, looking more longer term into the future, and you're from a very, from a country that sends us a lot of immigrants, which is great. I'm very pro-immigrant, given that I'm an immigrant myself. But you might be from a country where a green card is not readily available. The visa bulletin from the State Department provides you with information on how long the lines are. Sometimes they retrogress, so they go back in time. Sometimes oftentimes they go forth in time. So, and that concludes anything I can tell you about things to think about the immigration journey beyond OPT. I'm happy to answer any of your questions. Hopefully I can answer them, not because I'm stupid or I don't know, but I hope that it's not too complicated individual questions that maybe require an attorney. So thank you so much for your patience. I know I've talked a lot. I might need something to drink, and even my cat is bored right now. He's moved on. So thank you.
Thank you very much, Gabby. That was a great presentation. I can speak on that real quick from my perspective as someone who was also an F1 student here, then OPT, then H1B, then green card. As someone who went through this process, it is long, it is frustrating at many steps of the way. If anyone has any questions that maybe are not as specific to your situation, and can be asked for everyone else as well, please go ahead. You are more than welcome to submit your questions in the chat. If you have any specific questions that are for your situation, you can also ask that just please know that me or Gabby are not lawyers. We cannot provide the specific answers in many cases. Feel free to start asking questions. Raise your hand if you have a question, if you would like to ask it. And if not, please submit it in the chat. We'll give you a few minutes and we'll stay here until 6.
Yep, and Julia already typed up a very good question in the chat. So what's the process of applying for an O1 visa? Does the employer petition for your visa, or can an applicant apply themselves? And can my employer petition for an F1 for me, for a visiting professor? Do you mean an F1 or a J1, Julia? Because the F1 would require, oh, H1B. Okay. All right. No worries. No worries. There are lots of acronyms, lots of letters, lots of numbers, and it's basically just a word salad. So thank you so much for clarifying. So the process of applying for an O1 visa, basically you would best advised, English difficult right now, best advised to have an employer, an employment-based immigration attorney, because it's a very complex petition, because you want to make sure that you provide the most detailed explanation and evidence as to how outstanding you are, and that you have really risen to the top of your profession, that you have written, not just very impactful research articles, for example, but also that you have been cited numerous times. And there are statistics about what the top 5% or what the top 50% of people in each field are cited. And so yeah. And the O1 visa for your is an employment-based visa, so you would have to have an employer who would sponsor that. Unlike, there is a national interest waiver option for applying for permanent residency, where very outstanding people, think about, really think about people that have won major breakthrough prizes in their research. They can apply or have been awarded major research grants of millions of dollars. They can apply on their own for permanent residency, because it's in the national interest that they remain in the United States. And yes, if your OPT is over, you can certainly get a H1B. University can file for an H1B for you, based on a position at the university. Filing an H1B at the university is not necessarily easier, but the thing that makes universities very attractive is because we don't have a cap. We can file an H1B anytime. H1Bs can start anytime, and so we don't have to worry about April 1st or October 1st. And let me know if any of this was unclear. If you're going to be working at UC Santa Cruz, you'd be your department would initiate that H1B request, Julia, with my colleague Elena. It's a fairly easy process. It's very painless, and yeah. What I would suggest, though, is to get any of these petitions filed before your OPT expires, because that would protect you while you might not necessarily be able to continue work until you get the H1B approval. It will for sure protect you much more with your legal status. If it's always a little bit more iffy if it's applied for in the grace period, but even in the grace period, it's not the worst. All right, so then how do you find an employer sponsoring people? How hard is it to get an employer that's willing to sponsor an H1B? That is a very good question. the list that or not the list, but the web link that I provided as part of the resources lists the employers that have sponsored people for an H-1B. And after the 2008 economic crisis, the crash here in the United States, H-1Bs kind of dropped off a little bit, but now lots of employers are willing to sponsor H-1Bs. Maybe not for the initial 3-year period, maybe just for 1 year, and then go with an extension. But there are employers, there are still many employers that are willing to sponsor an H-1B. Jan, how long is the process for the H-1B visa to work in the university? So talking about our perspective here from the ISSS employment-based visa side, the scholar side, it takes us about a month to put together the petition, to look everything over, to submit the first step to the Department of Labor, wait the week, and then send it off to the Immigration Service. So I would not necessarily want to wait until it's a month out from your start date. The longer we can get, the better it is. An H-1B can be applied for up to 6 months in advance of the start date. To apply for an H-1B, do I have to live in the same area as the employer if I'm working remotely? That is a great question. And I don't know the answer. I'm sorry. Because my experience mostly is with university faculty members and university employees, and we all have to be, at least on a hybrid schedule. I'm happy to look into that, Jason, and find out the answer for you. And I'm sorry, I don't know that. Anybody else? Everything either crystal clear or everything is so complex and so confusing that you don't have the courage to ask. And the worst that can happen is just that I tell you that I will have to do some more research and I will get back to you. So I make a note of Jason's question. Okay, so we have another question. Will there be rejections for the spouse via H-4 application in the embassy? So you can get the H-1B 2 different ways. Like you can get any immigration status 2 different ways. You can either, most of the time for an initial H-1B application, it's considered to be a change of status application, where once, if you work for an outside company, once October 1st comes along and your H-1B was granted, you go to sleep on September 30th as an F1, and then you wake up October 1st and you're an H-1B. Or there's a process called consular processing, where consular notification, where basically the employer notifies, well, where the employer asks U.S. Citizenship and Immigration Service to notify the consulate or the embassy in your home country to have a visa ready for you and available for you, and then you would just go to the embassy to pick up your visa. The rejection for a spouse for the H-4 application in the embassy could only, I'm not saying that it's always going to be granted, because I'm not the one granting all of the H-4 applications in the embassy. But it's probably likely to be a question of, are you really married? And then do you earn enough money to have your dependent here? And basically, if you have an H-1B, you would earn enough money because of the prevailing wage and actual wage determination. And if you're really married, then your spouse should be able to get the H4 visa. It's not quite as iffy for an H4 to get the visa as for an F2, because of the lack of intent to return home requirement. I have read about the EB2 NIW. How can you tell me how hard it is to go this route? Okay, Cesar. Sorry if I screwed up your name, Cesar. So the EB2 NIW, so that's the permanent residency path. EB2 means so it's the second preference category, and so the NIW route is, I have seen faculty members, or not necessarily faculty members, but researchers, I should say, researchers at the university go the NIW route, and you should definitely work with an immigration attorney on that. That's well versed in the employment-based immigration regulations, because you will have to demonstrate not only that you are eligible, but also that you have an extraordinarily good case to make. Not just that you're an extraordinary individual and you qualify for permanent residency, but also that it is in the national interest to award you permanent residency. So you don't even have, you have to be able to document that you don't need to have the backing of any employer to get your permanent residency, but you're that strong in your field, whatever field that is, that it is in the national interest to have you be here as a permanent resident. So that's a very, very strong and could be a very difficult route. It requires a lot of work. So if you're the only other example that I can give you is for tenure track faculty. In order to get tenure, they have to put together this packet of information as to why they should be getting tenure and how they qualify for tenure. And it's kind of akin to getting another PhD in a way. And so I would kind of compare the NIW routes to that in terms of the work that's required in that regard. So it's not impossible. People do it. It's just very, very difficult. And you need a lot of documentation, a lot of, expert letters, a lot of things have to fall into play for the national interest waiver. So it is hard. It's not impossible. So what visa is appropriate if I do freelance work for multiple employers on top of having a permanent job? Excellent question, Yulia. And that brings us to another limitation of any of these employment-based visas, because they allow you to be employed and having a career in the US, and allow you to stay in the US and pursue, step 2 or 3 of an immigration journey. But the price you pay for that is not necessarily being able to have a lot of engagement outside of the activities for which whatever petition and whatever visa you're on were submitted to the US government. So we get this oftentimes from professors, for example, at the university that have speaking engagements, that get invited to share their research, and they get an honorarium, supposedly. I mean, not supposedly, but they're supposed to get an honorarium. And we have to kind of tell them that they can't accept the honorarium. Or, for example, if you were to write a book, then and the book would get published, of course, and then your publisher wanted to give you royalties. Again, that would not be something that you could do on an employment-based visa. That you would have to, you could only get the royalties once you're a permanent resident. So freelance work for multiple employers, is going to be very, very, very difficult. If you have questions about that, maybe working through like a agency or something. I don't know if each of these are individual gigs or individual works of art, or if they go through like an agent or let's say if you're an artist through a gallery. I don't know if that could be authorized, but again, I would have to refer you to a very highly qualified immigration attorney. And that makes it, again, it's somewhat unfair, and it's somewhat mean. I don't want to say mean, but it's that there are all of this is still you're still in a position where you're not so-called home free. The flexibility and the choice of what you want to do and ability to do pretty much anything you want to do in the US, that only comes with being a permanent resident. And even then, sometimes there are jobs that require secure government clearance, and then even being a permanent resident wouldn't cut it. You have to be a US citizen for those. So, and I'm sorry that this is the system, but it's not perfect. All right. Any last words?
Looks like all of the questions have been answered. Thank you very much, Gabby. This
Well,
was
thank you. Thank
very,
you so much,
very
everybody, for coming. And I wish you all the very, very best in whatever direction you're ending up, wherever life takes you, whatever opportunities you have. I hope you have a lot of opportunities, that you have that all of your talents, all of your gifts to that you have to contribute can be contributed to whatever society you want to contribute to them to. And I wish you really, truly all the very, very best.
awesome. Thank you very much, Gabby. Thank you, everyone.